Assalamualaikum warahmatullahi wabarakatuh. So this is your Zoom recorded lecture for to replace our face-to-face lecture. In the previous lecture, we have discussed, or we have completed discussion on the first two actions, okay, pertaining to trespass to person, and we discussed about assault and then followed by battery. So in this particular recording, we are going to discuss about false imprisonment. So this is the third category, or the third type, okay, of trespass to person, and it is called false imprisonment. But the word imprisonment here, it doesn't really refer, or it doesn't really mean imprison or prison per se. Okay, but basically the meaning, or actually it denotes something else related, but then not necessary imprison as we might think it is. Okay, so basically whenever we talk about false imprisonment, it means the infliction of bodily restraint, and it causes the confinement. So basically the keyword here is confinement of the plaintiff, okay, within certain area, okay, within an area determined by the defendant. So defendant is the one who causes the confinement. And of course, on the part of plaintiff, it is not expressly or impliedly authorized by law. I mean, it's not with consent of the plaintiff, and it's not justified by law. So basically the keywords here that we have to remember, or we have to take note, is that bodily restraint, and then confinement, as well as there must be certain area, okay, within certain area. Right, let's go further. Okay, so from this, the rule, or the meaning, or the interpretation just now, actually there are three, this is all the elements, okay? I mean, this is all uh, the, the element or the ingredients, okay, to constitute a false imprisonment, okay? First, it has to be the element is that it has to be false, or false here, it means wrongful imprisonment, wrongful confinement of plaintiff by the defendant. And the word imprisonment here again, okay, actually it refers to restraint, or restraining a person's liberty, a person's freedom to go to any place at any time he will, because this is actually personal liberty, okay, human rights here. And whenever we talk about liberty, okay, personal liberty here, so we need to cross refer to our federal constitution, which is the supreme law in the country, especially Article 5, subsection 1, or clause 1, sorry, Article 5, clause 1 here. It is stated that no person shall be deprived of his personal liberty, save in accordance with the law. So the keyword there is personal liberty. Okay, now we go to the element. So this is actually the further elaboration, okay, of the interpretation of the term false imprisonment. Okay, for the elements of false imprisonment, there are similar to assault and battery that we have discussed earlier. So they are all, they all contain three elements. So similar to them. So false imprisonment also contain three important elements. The first one, the restraint of personal liberty, or personal liberty has been restrained. That's the first element. And then the second one, the restraint was intentional. Of course, it is done by the defendant towards the plaintiff. And then the third one, restraint must be complete. So all the three elements here must be fulfilled. I mean, if one of the three is missing, then there will be no action for false imprisonment, or no liability for false imprisonment. Okay, we are going to discuss the element one by one. Okay, the first one, personal liberty has been restrained. What's the meaning here? Let's have a look at the case law, because it helps us to illustrate the application, okay, or the meaning of the element, or requirement here. The case is a common law. The case name is Walden and Home Office, reported in 1990, and also in 1982 appeal case. Here the plaintiff, okay, he was placed in a strip cell, okay, overnight, so one night lah. So what's the meaning of strip cell here? Strip cell, this is, I put there the definition of strip cell. It means a cell or prison, basically a jail, okay, without anything beyond a concrete bedding area, very, very basic one, okay? Bedding area, toilet, and a sink. And prisoners in these conditions, they wear certain clothing or certain uniform or smock, okay, a tear resistant gown here, tear resistant gown. I mean, certain it's like in a picture. Okay, basically that's the clothing. I mean, this is whoever is being placed in the strip cell, so they have to be. I mean, they have to wear this particular um, gown or uniform. All right. But now we come back to the issue which is important to us or which is relevant for our discussion here. So in this case, okay, when the plaintiff was placed or was put in strip cell overnight, so whether there was unlawful, whether a lawful imprisonment, okay, may be rendered unlawful. So initially it was lawful, but later it become unlawful. What's reason? By reason only of the condition of the detention. So by right, it shouldn't be put on the strip cell. But the court held that no, okay, it doesn't. The issue here is answered in a negative, okay, not in the affirmative way. So basically, the answer is no because it is still a lawful imprisonment. So it doesn't convert from lawful to unlawful. But whenever there's any case of false imprisonment, sorry, the word is false imprisonment, then the plaintiff, okay, is entitled to the remedies. So what are the remedies for assault, battery, or even for false imprisonment here? The remedies are damages, monetary compensation. So the remedy is not that you have to be released from the imprisonment, okay? So not the release of the prisoner, right? So it doesn't change the status of imprisonment. But here, the plaintiff is entitled to get monetary compensation. That's one of the most common remedies, okay, for torts action. Okay, let's move further. Okay, so basically, actually, you have more cases in your textbook, but this is only one of the cases to illustrate, to explain about the element, all right? Personal liberty has been restrained. Okay, let's move to the second element. Restraint was intentional. So take note, the word here is intention. It is committed with intention. So whatever restraint, whatever confinement here, it was done with intention on the part of the defendant. So having said so, it means that the restraint here, it was a direct consequence of defendant's act. So defendant was the one who caused the restraint and it was done with intention. So we have the case of Harnett and Bond, quite old case, reported in 1925. And in this case, the court established or the court observed that proof of intention was necessary. Okay, meaning that here from the act of the defendant, there must be evidence, okay, of intention, or proof of intention here. So what happened in this case? So who was the plaintiff? So plaintiff in this case, he was an inmate at a licensed house for lunatics. Okay, and actually he was granted a month's leave. But within that 1 month leave period, so he could be reconfined by the doctor who's in charge of his whereabout here, okay, of his matter. So by Dr. Adam, okay, in that period. And then what happened was that the plaintiff here, he went to the offices of the commissioners for lunacy and he saw another doctor, okay, Dr. Bond. And then Dr. Bond said, well, you are not fit, okay, to be granted with a leave, or you are not fit to be at large, basically, okay. So you cannot be free. You cannot be a free man, basically. So because of that, Dr. Bond, okay, so he sent a car, okay, to take plaintiff, all right, to Dr. Adam. So from Dr. Bond to Dr. Adam. And Dr. Bond detained the plaintiff, okay, while pending the arrival of the car. And the detention confinement here is lasted for 3 hours, okay. So it's pretty a long time here, 3 hours, okay. And later plaintiff brought action for false imprisonment by Dr. Bond. So the court held that Dr. Bond here had no right to detain the plaintiff pending the arrival of Dr. Adams. And because of that, okay, Dr. Bond here was liable in damages for that particular 3 hours illegal detention. So basically the remedy here would be the damages, okay. All right, so that's an example of the case for the second element. Okay, the second element again, the restraint was intentional, so it was done intentionally by Dr. Bond. Okay, all right. So we let's move to the third element. Still about restraint. Okay, restraint here must be complete. What's the meaning of the word complete here? It means that there's no reasonable means of escape. There's no way for the plaintiff to escape from the confinement or from the restraint here. And then we have 2 cases to be discussed. We are going to discuss Bird and Jones, landmark case. Okay? And we also have the case of Meering and Murray. We have 3 cases altogether. But in relation to no reasonable means of escape, okay, another important requirement is that whether, okay, the knowledge of the plaintiff was that he was actually restrained, is it material in or immaterial to prove this element or to fulfill this element? Basically, the answer is no. I mean, it doesn't matter whether the plaintiff was aware or didn't know when actually he was restrained. Maybe he got to know about it later, so it's okay. I mean, you can still, I mean, the requirement is still can be considered as being fulfilled. So let's have a look at all the cases to understand the requirement better, the elements better. Okay, first we are going to start with Bird and Jones, a very old case, 19th century case, reported in 1845. What happened was that, more or less like in the picture here. So defendant, he wrongfully enclosed, okay, part of the public footway on a bridge. So there's a bridge and then there's certain part which is used or meant for public footway. Okay. And then because there was occasion here, there was certain event running, okay, here. So the seats, okay, were placed for spectators of a regatta on the river like this, okay. And defenders, he was on that side, okay. So defenders refused to let the plaintiff to go forward in the enclosure. Say, okay, you have to stop. You cannot go forward, okay, stop. But defendant was told that please go back, okay. You could go back to the gate and you can actually get out, okay, of the enclosure. I mean, up to you. If you wish, then you can actually get out. You can go back, but you cannot move forward, all right? But the plaintiff was not happy. He didn't want to get out or move backward. Okay, he want to go forward. So plaintiff just remained in the enclosure. Okay, and it lasted for half an hour. And because of that, okay, he filed a suit here. So he sued the defendant for false imprisonment. All right, but when the court decided, or when the court heard about the case, or when in the course, I mean, the observation by the court here, actually there was no false imprisonment. Why is that so? Because the restraint was not complete. Okay, because he could go back, so it's not complete. There's a means of escape here. I mean, he could get out from the area, actually, the area that he alleged that he was being restrained. Okay, let's say if we twist the facts a little bit, for example, he couldn't move forward and he couldn't actually move backward. I mean, he couldn't get out from the place. Then yes, it is a case of false imprisonment because the restraint was considered as complete in that particular situation. But for this case, he could get out, okay, easily, but he didn't want. Okay, he just remained there. So he tried to sue and ask for compensation, but the court denied the claim. Okay, the court said there's no false imprisonment because the third element was not being fulfilled. Okay, it's not complete. It's not complete. It wasn't a complete restraint. Okay, in another case here, the case name is excuse me for all the noises because my neighbor is doing renovation work. Okay, so there might be noises from time to time. Okay, next case here that we're going to discuss here, Meering and Graham White Aviation, reported in 1919. Here, the defendants in this case, he was the policeman. They were policemen, more than one policeman. And then this policeman, they suspected plaintiff of committing certain crime here, okay, stealing varnish from the employer, his employer. And plaintiff was asked to follow defendant to the company's office. I think this is some standard procedure, okay, because of the suspicion. So you need to follow the police, okay, to make or whatever relevant investigation here. So plaintiff followed and waited in a waiting room, okay. But the policeman just left. Okay, policeman remain in the neighborhood. I mean, there's no investigation whatsoever. Okay, and then when the plaintiff brought an action for false imprisonment, policeman said that I mean, you can actually you are free, okay, to go where you wish. Okay, I mean here there's no policeman around, so you can go actually. But when the case was brought to the Court of Appeal, the court held that no, okay, you defendant was liable in this case because why? Normally, okay, once you were under police investigation, okay, even though you are still waiting for it, but actually normally, okay, plaintiff was no longer a free man. I mean, it's not free for you to go as you wish, okay, because the police is about to do the investigation. And then the court held that yes, okay, clearly from this case there was intention to restrain the liberty of the plaintiff. That's why he was made to wait in the waiting room in the first place. Okay, so it's not. I mean, it is. It doesn't make sense. Okay, if police were to say, "Oh, you are free to go," whereas investigation was going on. But the thing was that the policeman was not around. Okay, they were in the neighborhood doing some other things lah. Okay, right. So basically, here defendants was not liable. It was a case of false imprisonment. The restraint here was complete. Okay, let's have a look at another case here. Murray. Okay, just now mirroring. Okay, now Murray. This is judgment by L. Griffith, okay, and it is stated, this is his observation here. It is not an essential element, okay, that the victim should be aware of the fact of denial of liberty. Meaning that here, let's say the victim was not aware, but later he was aware of it. So could he sue for false imprisonment? Actually, yes, he could. Okay, so from this particular judgment or the ratio here, we can extract that knowledge is not essential. So meaning here a plaintiff could be false imprisoned, okay, could be under false imprisonment, okay, even if he was unconscious or he was asleep or even he was drunk perhaps, okay, here. I mean, because why? Knowledge is not really an element. So long all the three elements that we have discussed are being fulfilled, then it amounts to false imprisonment. Okay, so we are done with all the elements here. But having said so, now the next thing we want to do now is that we want to see what are the defenses which, which could be raised, okay, which could be proved on the part of the defendant. So these defenses will be applicable to all actions relating to trespass to person. So it will include assault, battery, as well as false imprisonment, depending on the facts, depending on the situation here. So there are at least five common defenses here. Okay, we have lawful arrest, we have consent, okay, we have reasonable condition, we have necessity, and we have self or private defense. So if you remember, actually, especially consent, necessity, and private defense here, it has been covered in part one of torts, okay, when when the lecture or when the discussion about general defenses was conducted, I believe last semester, okay. But let's have a look at all the defenses here, especially the notable one. Okay, consent. Okay, consent. I think if we were to refresh, it is something to do with voluntary non-fit injury. Okay, remember? Right, but now it's more specific now. Okay, we look at the consent per se. So basically, especially whenever it involves medical treatment or medical negligence here, okay? So adult, the issue, okay, would revolve around adult who does not consent, or a child who's not capable, not competent to give consent. Okay, similar to plaintiff who is mentally unsound. It's not legally capable of giving consent. So what's the position in that particular situation? For example, we have this case, F and West Berkshire Health Authority reported in 1989 here. But the argument was that whatever operation here, it was performed, but for the best interest of the patient, and the patient was not capable, incapable of giving consent. It was about, it involved a woman, okay, the age was 36 year old, and he had mental age of a minor. He was mentally unfit, basically, right? And because of that, her mother was asking for a declaration, okay, from the court to the effect that it will be lawful. The mother is doing whatever necessary on behalf of the daughter. So it will be lawful, okay, to do what? To sterilize, okay, her daughter. Because now the daughter was living permanently at a mental hospital. So there's a need to sterilize so that she wouldn't become pregnant, okay, if there's anything unwanted thing happen, okay, to her, because the mother was not there, okay, to take care of her daughter personally. And of course, as far as the doctor was concerned, this 36-year-old woman here, she was unable to give consent, okay, whether she consented to the operation or not, whether she consented to the operation or not, because of her mental situation, okay, mental condition here, mental age here. And then another important case was that, which is relevant, okay, to our discussion here, the case of Airedale, NH Strass, and Bland. So here is about, it revolves around the issue whether the treatment could be ended, okay, because there's also there was absence of informed consent, because as far as the patient was concerned, he was in persistent vegetative state, so not able to give consent whatsoever. Okay, whether whether there could be consent to end his treatment. Okay, after a long period of time. Okay, let's have a look at the facts here. All right. If you notice, if you remember, okay, when you discussed about nervous shock last semester, okay, it relates to Hillsborough disaster. Remember the stadium which caused so many deaths? So this is one of the victim, but he survived actually in the incident. So Bland, the name was Bland, okay? Mr. Bland here. So he was injured in the Hillsborough disaster. And he was 17, okay, at the time of the incident, 17 and a half years old. And because after the incident, he became vegetative, okay? He was left in a persistent vegetative state. And then he remained in this state, okay, for over 2 years, more than 2 years, all right? And no signs of recovery, no signs of improvement. So the only thing which kept him alive was a life support machine, okay? But he could breathe by himself, but he required feeding via tube, and of course he need full care, and he has been receiving full care for that particular period of time. And then the doctor, okay, who was in charge of his treatment here, so they were granted approval to remove the tube, okay, that was feeding him, because it seems that no, I mean, in terms of the recovery process or the chance to recover, as if zero chance, okay, to recover here, no sign of improvement at all. So the doctor, asked for approval to remove the tube, because there's no point of maintaining the tube here, okay, to just keeping him alive, right? But then, the decision of the doctor here was objected. Okay, so that's why this decision was then appealed to the House of Lords by the solicitor acting on Bland's behalf. I mean, the lawyer said, no, the doctor shouldn't be granted approval to remove the tube here. So now House of Lords was deciding the case. So what happened to the case here? All right. So this is the issue. Okay, before we go to the decision, so this is the issue. The court said that, House of Lords said that a patient that is in a persistent vegetative state, of course, okay, he or she cannot withhold or offer consent for treatment. Cannot say I want the treatment, or I don't want the treatment. Cannot say so. So because of that, okay, this specific situation, it requires doctor to act in the best interest of the patient. I mean, whatever doctor's action here, it has to be for the best interest of the patient. So in this particular case, okay, whether the continuation of Bland being on life support machine here, is it for his best interest? Okay, remember, there's no sign of improvement or signs of recovery at all after 2 years plus, right? So the court held that on the basis, okay, that there was no potential for improvement. It's like zero improvement, okay? So now, the treatment Bland was receiving was deemed not to be in his best interest. I mean, there's nothing much that to help him, okay, with the treatment or recovery here. So the court held that it is not lawful to cause or accelerate death, because the moment a doctor decided or is given the authority, the right to remove the tube as well as life support machine, so actually it will be the cause of his death, or it will accelerate his death. But the court said no, it is something which is lawful. It is not lawful here. Not to be in it was reviewed. So it is not lawful to cause or accelerate death. Oh, sorry. Okay. I need to rephrase. So basically here, the court said whatever treatment here, okay, not to be in his best interest. So still, okay, it is not lawful to cause or accelerate death. But whatever action by doctor here, it has to be in the best interest of the patient here. It sounds a bit confusing here, right? You might want to read a longer report or full report. Okay, this is just the summary. But basically, that's the observation by the court here. All right, let's move further. Okay, now we go to the federal constitution, which talk about, which is in relation to personal liberty. Yes. Okay, Article 5, okay, Clause 1 of FC, okay, Federal Constitution, says that no person shall be deprived of his personal liberty save in accordance with the law. And another clause, Clause 3, okay, 5 Clause 3, it is stated that if the person is arrested he must be informed on the grounds of arrest. Okay, this is also another personal liberty. Okay, the right of the arrested person here. And Article 5, Clause 4, actually it's the same with Section 28 and 17. I think it's the same. Okay, so we are going to have a quick look on all the relevant sections. All right, this is the reproduction, okay, of the provision, okay, the full provisions in um, federal constitution, okay. So you can see the heading here is about fundamental liberties under part 2. So we talk about liberty of the person. So we have clause 1, okay, clause 2, clause 3. Okay, we are going to come back later, okay, at all the relevant section. All right, let's move to the second defense, okay, for an action for trespass to person, which is lawful arrest. Mean that here, in certain situation, whatever arrest made by authority, by the police, for example, it is something which is lawful, so that there's no way for the arrested person to file a suit or to make the police liable, okay, provided it was done lawfully or it involved lawful arrest. For example, okay, an arrest made lawfully, having said so, it means that an arrest made lawfully, it won't amount to false imprisonment, especially, okay, if the arrest was if done, it is done with a valid warrant of arrest. So most of the time, we need this warrant of arrest to make it a valid arrest. But if you were to look at CPC, okay, Criminal Procedure Code, it provides for, in some situation, there could be arrest even without warrant, but only in limited situation, in certain circumstances here. Okay, all right. Still on the discussion of arrest and restraint here. So what's the meaning of the word arrest here? So arrest means the seizure, okay, or contact with the body. Okay, in order to make an arrest, then there must be contact of body, okay, of an individual. So what's the intention? Okay, intention is to restrain him. Okay, he couldn't be let free basically here. All right, but again, the caution words here is that powers of arrest is not absolute. Okay, that's why in most of the situation we need warrant, okay, to justify the arrest here. And as I said just now, whenever a person being arrested under federal constitution, the person has to be informed. Okay, what's the ground? Okay, on what reason that he was being arrested here, and he has the right, okay, to be defended by a legal practitioner of his choice. So we have a case here which involve arrest under the previous ISA, okay, Internal Security Act 1960. The case was Abdul Malik bin Hussein and Burhan bin Haji Daud in 2008. And then appeal, all right, Burhan bin Haji Daud and Abdul Malik, and the one in 2010. Okay, I don't put the full facts here. You might want to refer to your textbook, okay? But basically, it revolves around arrest which was done under ISA, okay? Internal Security Act. Okay, let's have a look at another case. Kwan Kwai Choi and Ikezaidi bin Pak Matali, 1993. Here, the defendant in this case was an inspector of police, and he did arrest, okay, the plaintiff. He made the arrest, but he has a warrant of arrest, okay, and he quickly brought her to the police station, and then he locked her up at 10:30 a.m. But actually, he was supposed to bring her to the court, all right? But he did not bring her to the court on that particular day. So because of that, plaintiff sued the police inspector, and she was asking for damages for false imprisonment. And the court, in order to decide, okay, or to give judgment here, the court referred to Section 47, okay, of CPC, and then under this particular section, okay, it is stated that police officer who executes a warrant of arrest, okay, shall, so that's the obligation, okay, shall, legal obligation, without unnecessary delay, bring the person arrested before the court. But in this case, the finding by the court was that, yes, it amounted to unnecessary delay. So yes, it is a case of false imprisonment being committed on the plaintiff, okay, because she wasn't brought to the court on that particular day, the same day. Okay, that's unnecessary delay. I mean, there's no grounds or no justification, okay, for the delay here. All right, so let's have a look at arrest without warrant. In what situation it might be allowed here? So we are going to cross-refer to CPC, okay, a few sections here. So we have section 23 of CPC, which provides for arrest by police or penghulu, all without warrant, okay? And then section 27, it provides for arrest by us, lah, okay, by all of us here, private citizens. And section 28, it talk about duty of the arrestor. And section 117 of CPC, it spells out the duration of the arrest and also magistrate's power to extend a remand order, okay? So it sounds so criminal in nature, but then it is actually applicable, okay? This is a good defense, okay? Whenever there's a case of especially in the case of false imprisonment, okay, in order for the plaintiff to claim for damages, okay, monetary compensation. Okay, let's have a look at one by one. So if you were to read section 23, okay, it talk about seizable offense, okay. So the arrest, I mean the power of arrest without warrant here is given to police or penghulu, but it must be with regards to seizable offense. Okay, what's the meaning of the word seizable offense? So if you were to refer to penal code seizable offense here, it means whenever it is about, I mean, it relates to murder, okay, all the serious offense here. Possession of offensive weapon, wrongfully confining a person with intent to extort his property, okay, obstructing a public servant in discharge of his public function, abetting the commission of suicide, okay, assault or criminal force in attempting to commit theft of property, or dishonestly receiving stolen property. So this is all the example of seizable offences. So whenever the offences relates to this, then yes, police or penghulu, there's no need to get a warrant, okay, in order to make an arrest. So the arrest could be done without warrant, but only with regards to this crime, okay, the rest then cannot, okay, if it is beyond whatever listed here. Okay, but again, okay, first is about seizable offense, okay, and then there must be reasonable complaint or credible information has been received. In that here, there must be certain reasonable suspicion, and then who will actually prove this? Okay, that I mean, the arrest was made because of this reasonable complaint or reasonable suspicion here. So burden of proof is placed on the one who make the arrest, the arrester, or the police or the penghulu. Okay, they cannot simply go and arrest, okay, without any complaint or without any credible information or without any reasonable suspicion here. All right. So this is the further elaboration, okay, of the word or requirement of reasonable complaint or credible information here. So complaint basically it means allegation, okay, which is made orally or even in writing to a magistrate with a view to his taking action under CPC, okay, to some person who has committed or is guilty of an offense. So that's complaint, more formal here. But credible information, it means any information, all right, that the police officer, so in the exercise of his judgment, appears entitled to act. I mean, it's discretion of the police to act or not to act, okay, for that particular circumstances. For example here, okay, the person who reported to the police is proved to be reliable. Okay, I mean, whatever information, it has to be from someone who is reliable. For example, police informer, okay, or maybe this person in previous cases, he has managed to assist the police, okay, to lead to arrest here, or even to for prosecution or conviction. I mean, it cannot be anyone here. It has to be, the information must be from someone who is reliable, okay, reliable, or even police informer. That's the term. Okay, let's have a look at the case here. Abdul Rahman and Tan Joko, 1968. Okay, so respondent, R is respondent, okay? So he suspected the appellant of carrying a concealed weapon upon his person in a coffee shop. I mean, there's a suspicion here. So because of that, respondent invited the appellant to the police station. But appellant didn't want, okay, refused. Right, because of that, the police, okay, dragged the appellant to the police station. But not far, okay, just drag, it's about 100 yards away. You can imagine how long is, I mean, the distance of 100 yards here. And then the police actually recovered a knife from the fold of his sarong, okay, play card, I think, sarong here. So because of this, okay, so meaning here suspicion was, I mean, it turns out to be true. All right, so it is something which is reliable. So the court held that yes, the detention to conduct the force was not forced imprisonment. It doesn't amount to false imprisonment. So FIR is actually acronym for false imprisonment. Okay, let's have a look at another case here. Compare with earlier case just now. Earlier case was okay. Abdurrahman kan, Abdurrahman Tanjoko 1968. So this one 1969. Okay, a year later, Shaban and others and Chong Fook Kam. So in this case, the appellant, okay, who was the police constable, he arrested two, okay, not one, okay, two respondents on suspicion that one of them was driving a lorry recklessly and negligently. Because why? A timber from the lorry, like in the picture, okay, hit the windscreen of a car, so it caused the death of one of the passengers. So mean that here, the two respondents was the suspect. But when the case was brought to the court, I mean, there's no enough evidence here. Okay, the court held that there was no reason to suspect the lorry was driven recklessly. I mean, lacks of evidence here or information. It's not credible enough. So because of that, okay, I mean, distinguishing from earlier cases now, in this case, the appellant, the police was liable for false imprisonment. Okay, earlier case, no false imprisonment. Okay, but here, I mean, there's no case of false imprisonment, right? Could be a wrong suspect lah altogether. And after all, it was not based on credible information. Okay. And then I mean, in relation to evidence, okay, or proof here, it is stated, I mean, it was made clear that it is unnecessary, okay, for the police to show that there was prima facie proof. I mean, is it a strong case to prove the suspicion here? And the court said that, yes, police can arrest if a reasonable suspicion existed, okay, of the plaintiff involvement in the offense. But here, it wasn't made up, okay? I mean, it doesn't reach that particular stage or requirement here. I mean, it doesn't amount to reasonable suspicion. I mean, there could be suspicion, but then it's not reasonable enough here. And Privy Council in this case held that suspicion in its ordinary meaning is a state of conjecture, okay, or surmise where proof is lacking. I mean, when you suspect, but you don't have strong evidence here, okay, lacks of proof here. Or in other words, I suspect, but I cannot really prove. Okay, suspicion is there, but cannot prove. So suspicion arises at or near the starting point of an investigation, just before investigation. So of which the obtaining of a prima facie proof is the end. I mean, the moment it is a case of prima facie, then it is a strong case, okay, to proceed with the trial lah later. All right. So that's basically the explanation, okay, or observation by Privy Council. Okay, now we go to a citizen arrest, okay, which is provided in Section 27 CPC, okay, Criminal Procedural Code here. So it is stated, I mean, it is required, it is provides, okay, it is provided in this particular section. Citizens may effect arrest if, in his view, the person has committed a seizable offense. I mean, now it is about the view of the citizen, okay. If it relates to seizable offense, then citizen can do the arrest here. All right, I reproduce the provision. It's pretty long. This is for your reading purpose. So this one 27 kan, earlier one. But for citizen, for citizen arrest here. For example, here it is stated, any private person may arrest any person, okay, who in his view commits a non-bailable or seizable offense. But okay, later shall without unnecessary delay hand over the person so arrested to the nearest police officer, okay, or in the absence of police officer, take the person to the nearest police station. So cannot hold or cannot arrest or cannot restrain or confine, okay, the arrested person with him. I mean, need to hand over to police, okay, as far as possible. I mean, immediately, urgently. All right, not unnecessary delay whatsoever. So you can read subsection 2, 3, or 4, and 5, okay. So section 28, it talk about duty of the arrestor, the one who make the arrest, okay, under section 28 CPC. It is stated that penghulu or citizen, whoever makes arrest here, shall without unnecessary delay take him to the police station. And on the part of the police, okay, police also shall without delay take him to magistrate, because magistrate will decide whether want to give remand whatsoever, okay. And then police cannot detain for more than 24 hours, okay. That's, I mean, if it is more, or if there is delay which is done unnecessarily, then I mean, the arrested person can sue the police later for compensation. I mean, for damages under false imprisonment. Okay, and this is the summary from this. Okay, you can have a look later. Subsection 1, subsection 2, and subsection 3. Okay, what now still about CPC, another relevant or important section here, section 117. Okay, what if investigation cannot be completed within 24 hours? Okay, so now it is on, I mean, the duty is imposed on the magistrate, obligation now is on the magistrate. He has discretion. Okay, he may authorize detention for a term, okay, not exceeding 15 days. That will be the maximum. Okay, from the day the person was arrested. So investigation should be completed within 15 days, more or less 2 weeks lah, right? And this is the for your reading purpose, it's a long, I mean, it's a long provision, but basically it talk about the procedure. Okay, it's procedural matter. Okay, so I mean, we have discussed two different so far. So now this is the third one. Uh, I mean, it is applicable for action or thoughts of a trespass person. So it is it is called reasonable condition. Mean that here, if there were reasonable circumstances, okay, in which the plaintiff was restrained, then there might be no false imprisonment depending on situation. Is it reasonable, okay, for the plaintiff to be restrained for that particular situation? Okay, if the answer is yes, then there will be no false imprisonment. So we have two cases we discussed. We have the case of Robinson and Bellman. And we also have the case of Hurt and Weardale. What happened in Robinson and Bellman Ferry here, 1910? Okay, Robinson, he paid a penny, okay, to cross on a ferry. Okay, but he narrowly missed the ferry. So he changed his mind. He didn't want to use the ferry. So he changed his mind about crossing. He didn't want to use the ferry. So now he wanted to leave. Okay, he attempted to leave through the gate he came through. But it required another penny to be paid to leave. I mean, you pay to enter and you need to pay if you want to leave. All right. But he said, no, I didn't use the ferry, so I don't want to pay. All right. So he refused to pay the penny because he said he had not crossed on the ferry. But the ferry company, okay, Balmain New Ferry Company, forcibly prevented a respondent, okay, Robinson, from leaving until he paid the penny. Oh, we can allow you to leave unless you pay us a penny, okay. So now he's claiming false imprisonment against the ferry company here. But the court held that there was no false imprisonment because the charge for exit was reasonable. I mean, it's the right of the company to impose such a charge lah, okay, such a rate. I mean, it is imposed on everyone. Doesn't matter whether you cross with the ferry or use the ferry service or not here. Okay, if you want to leave, then you have to pay. You enter, you pay, and then you want to leave also, you have to pay. Okay, and another case. Sorry. All right, Hurt and Willdale Steel. This is 1915. Okay, this is now 19. This one 1910. Okay, all right. This one 1915. This is about minors, okay? You can see the picture there. So partway through his shift, so a minor, so he demanded that he be taken to the surface. I mean, he has not completed his work shift, but he said, no, no, please take me up, okay, to the surface lah, basically, because it was down underground. But the employer, okay, refused his request. So because of that, he said, oh, I was confined, okay, because I demanded to be taken, okay, to the service, but you rejected my request, so now I'm asking for compensation for forced imprisonment. But the House of Lords said, no, 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 okay, I mean, we shouldn't allow the action here, because why? His employer were only obliged to transport him to the surface, okay, at the end of his shift. So he has yet to complete the shift, so there's no right for him to demand to be taken up to the surface, okay. But actually, if you were, they can sue under breach of contract, not really under torts here. So the minor could sue for breach of contract to bring him to the surface, provided there was a contractual duty on the part of the employer. So still, if he were to sue under breach of contract, maybe he might not succeed as well. Okay, because employer has the right to retain you to finish your work. Okay, you complete your work, then only we take you up to the surface. Okay. Right, that's basically the case of Hurt and Wardale Steel Company Limited. Okay, the fourth defense, okay, necessity. I mean, you can actually refresh. I mean, it's the same discussion, okay, that you had during your part one, okay, of your thoughts, okay, and also about self or private defense. You know, here, if if the situation falls under necessity, there might be no liability for assault or battery or false imprisonment. Necessity, usually it involve to save life can usually, right? It's a matter of life and death. So usually the court will allow the defense of necessity depending on how urgent the situation was. Okay, for self-private defense here, for example, in assault or battery, okay, can the plaintiff actually retaliate or do something, okay, to defend himself here? So the answer could be yes. Okay, a person may use reasonable force. That's the word. Okay, reasonable force. To defend himself or to defend his property. Or whoever he is bound to protect. But the force must be reasonable. Must commensurate. Okay, the force which is done by the defendant. I mean, cannot use excessive force in order to use the defense successfully. Okay. All right. Okay. I think this is the last one. Remedies. Okay. I mean, this is actually applicable to all tortious action. So we have damages. We discussed already in the early semester. Okay. And we also have injunction. Okay. These are all the remedy. We also have self-harm. We also have habeas corpus. That one is relevant. Okay. Especially for forced imprisonment. So what is habeas corpus here? It is a writ. Okay. A court's order require a person under arrest to be brought before a judge or into court, especially to secure the person's release unless lawful grounds are shown for their detention. So this is the right on the part of the arrested person here. Okay, they might be asked. I mean, they have the right to ask for habeas corpus depending on the situation. Okay, especially if no lawful grounds um, was shown or was informed to them. Okay, here injunction, it means official order given by a law court, especially to stop someone from doing something. For example, assault, battery. Okay, if it is continuous, then we need injunction so that the defendant would not would not continuously commit assault or battery, okay, towards the plaintiff. And then for self-help, this one, it has to be used with caution here, okay, but still it is a remedy. So it refers to individuals' implementation of their rights, okay, without resorting to legal writ or consultation of higher authority. I mean, you take the law in your own hands, lah. Basically, you help yourself here, but it has some limitation, obviously, okay, cannot abuse it, and then, I mean, the right is very, very limited, right here. I think that's all. So we are done with the topic of false imprisonment together with all the defenses. And we close with a remedies here. So I stop share and I stop record. I think that's all for now. So, Assalamualaikum warahmatullahi wabarakatuh.